Hello friends, welcome to Civilspedia. In this edition, we are going to see the current affairs related to 30th July 2018. So we have two set of topics we are analyzing. One is about the Prevention of Corruption Act 1980, recent amendment which was made in 2018. And second is about the Personal Data Protection Bill of 2008, which was submitted by Justice B.N. Krishna. And coming to the first one, like Prevention of Corruption Act of 1988, which was recently amended. So it was due pending for a long time, almost for 5 years. And after a series of discussions and deliberations, after it went to the referred to a standing committee, and then now it has been passed in the parliament. Okay, now let us see the features of it, what are the features of these recent amendments. And on your left is the one which is about the recent amendments made. On the right is the previous thing. All right. So first is about the definition of bribery. The definition, first thing, they have included a word undue advantage. Okay. So what is this undue advantage for? Okay. Whenever I speak about undue advantage, so here it is a one So here it is one whenever I speak about undue advantage, okay. So here it means any gratification other than legal remuneration. So now they have expanded the definition of bribery that includes not just a monetary gratification beyond that, okay. So only if it is about this concept, previously it was only related to legal remuneration, but now it has specifically mentioned about undue advantage. And the other thing is about the abatement. So previously only an abatement of an offense related to a public servant. Only these public servants who has been instigating or assisting for that the offense of corruption, they will be tried under this act. But now even giving a bribe is also punishable for a term of 2 to 7 years. So now both the bribe giver as well as the bribe taker, they will be punished. Okay, but this is a major point of contention as far as this is concerned. This has been vehemently opposed by the civil society as such. All right. So why in this case? So who is a bribe giver? Okay, so bribe giver is the one who gives say money, all right, money or whatever the gratification in the form of anything, a gift or whatever it is, all right. So now what is the 7 days? So there are two types of briberies. One is about the collusive bribery and another is coercive bribery. So what is collusive bribery? So normally collusive bribery in the sense both the bribe giver and the bribe taker, they intentionally they involved in corruption. For instance, a person who is approaching the government public servant for say a license or a contract, okay, so as to give some sort of a preference to him, some sort of a preferential treatment to him. So he collides, in collaboration with the public servant, so he gives money as well as benefits something indirectly. So that is called as a collusive bribery. So what is coercive bribery? Normally in cases where a public, in order to get some sort of an entitlement from the government as a right. So for instance, if you want to get some sort of an certificate from the government, whenever you want to get a certificate at a certain point, so for getting a license, for instance, your motor vehicle license, so to give a license, the public servants may demand some money, okay. So there you are compelled to give such money. So that is called as a coercive bribery, which is no, you don't wantedly you don't give the bribery, but you are forced to give. So that is called as coercive bribery. Bribery. All right. Here the contention is that the act fails to differentiate between collusive and coercive bribery. Okay, so in the case of coercive bribery, if at all you are giving bribe unwillingly, so out of you are demanded, you are forced to give, in that case, within 7 days of that giving bribe, or else that incident happened, you got to go to the police station. Okay, but here again, this is the major opposition. They say, what if the police also fails to take this complaint within 7 days? If at all there is a delay from the police side, what could be the impact? So this is again the major point of contention. Okay, because what about the coercive bribery, the one who is forced to give the bribe? Okay, so second is the case of pre-investigation approval normally. Okay, so initially if you see this sanctioning, there are two sort of sanctioning. One is at the level of approval at the level of investigation, there is sanctioning at the level of prosecution. Okay, so what is the stage? Once a person gets to prima facie says that a public servant is involved in corruption, normally he cannot be investigated by the authority. For instance, CBI, they cannot directly investigate Even for investigation right now, you need the permission of the relevant authority, which has not been defined, which may be notified by the government later on. So here it may be the relevant authority or the government which may be given the notification. So initially there was no such provision with respect to investigation. Investigation can be done without the approval. All right, this is the major change again. Third is about the sanctioning. So what is the sanctioning? So if at all after this investigation, once you want to so arrest and say file a charge sheet and all, so now the sanctioning of the previous authority like the governor or the president or the other authorities notified by them, so they'll be giving the sanctions under the criminal procedure code as well as under the protection of prevention of corruption act. Okay, initially before this amendment it was only for the serving officers, but right now this has been extended to the formal as well as retired employees. So we'll see why these sort of things are given. Okay, because like these retired employees, maybe if at all they have given some decisions, they have made some decisions with a good intention, without any bad motive, like then they can be only if at all there is a prima facie evidence that there is some sort of an kind of an very bad intention they had about corruption, then they can be prosecuted. Okay, so the manner and all those things will be notified by the center actually, but the only thing which has been said in the sense, all those sanctions has to be done within the time limit maximum of 3 months, which can be extended for another month maybe, so but not more than 4 months. The sanction has to be said whether yes he has to be prosecuted or no. All right, so coming to the last part of criminal misconduct, what is this in criminal misconduct in the sense, like for instance, when we are speaking about criminal misconduct, initially it was there were 5 grounds, now it has been reduced to 2 grounds. Okay, so now only if it is about misappropriation of property entrusted to public servant or intentionally enriching oneself illicitly, only on these 2 grounds he'll be tried under criminal misconduct. So there are 2 things, one is about bribery, one is about criminal misconduct. So bribery is directly getting in remuneration or undue advantage. Here it is another case. The reason behind like bringing in from 5 to 2, why to bring down the grounds from 5 to 2 in the sense, the justification given by the government to regarding all those things in the sense, recently the cases of Aircel case or in the Maharashtra bank issue and all, people who are who are in the directors or in the bank officials, they have been filed charge sheeted case on the basis of some RBI regulations, not on the basis of bribery alone, but on the basis of misconduct, wherein they have not made any private pecuniary gains. They have made only like a kind of loss. See, for instance, I'll give you a simple example. These days we are speaking about NPA, non-performing assets. So most of the cases, like in the case of this Punjab National Bank case and all those things, there is a loss to the public assets. Okay, but the thing is that whenever such decisions are made for giving a loan to someone, like that indirectly affects makes a loss to the public. That doesn't mean that they have made like the persons who have given the loan approval, they have made some benefit out of it. Meaning what? Only if the bank officials with the intention of making some money or indirectly they made some sort of money in the form of an property or whatever it is, enrich themselves, only then they can be punished in the Corruption Act, not for a mere kind of other things. All right, so this will like why this was taken in the sense, previously like after these prosecutions and all, now the bank officials and the public servants, they are very hesitant to take decisions. Okay, so this decision making hesitancy which has impacted the economy as a whole. All right, so whenever people are like very hesitant to give loans or something like to the government, to the companies, that will hamper the growth of economy indirectly. All right, that will disrupt the flow of money. So that is the reason why so also take the decisions. If at all you make so much of a stringent provisions and all, then the officials and the public servants, they'll sit simply without approving anything, because only if you give any approval you'll be in trouble. So in that case nothing will happen. So that is the reason why they have brought down this number of misconducts from 5 to 2 as a ground actually. So only if they are enriched themselves in the terms of property or something else, but not for a mere public loss, they won't be prosecuted. So this is another case actually. Next is about the forfeiture of property. Initially there was no any such provision regarding that, but now there is an attachment configuration by a special court. The special court is already there. All right, so now there is another thing which is again at the discretion of the court. And lastly about the time limit. So initially in the actual act, there was no such provision, but now a maximum time limit of 2 years, which can be extended for every 6 months by giving reasons. But at any case, it should not exceed more than 4 years. So this is the case, and so this is normally the major amendments made in the Prevention of Corruption Act of 2018. So let us wait for like how far it is going to be implemented, how effective it is going to be, and maybe from the side of economy, from the side of curbing the corrupt practices. All right. So next, coming to the next topic of data protection bill, like recently this being Sri Krishna committee was appointed for that, like, and they have submitted the draft bill to the government yesterday. Now here it is the reasons they have given. What is the reason for this bill to be enacted? One is about the recent right to privacy judgment given in the right to Puttaswamy's case, where they said right to privacy is form of fundamental rights, and when that has been said, personal data is an essential facet of information privacy. So now that is a reason, like that is one of the prime most reason to forming the bill. And secondly, we are speaking about digital economy. So now with the growth of digital economy, where the usage of digital economy, not just in the form of monetary transactions, even the non-monetary transactions are on the rise. So in this case, there is a need to have such a data protection bill, where because data now is used as a critical means of communication between the persons. All right, not just between the government and the persons, individual assets, but even among the persons also. And thirdly, one of the prime reason is to create a collective culture that fosters kind of an balanced view. One is about the information privacy, another on the other hand to have a free and digital fair economy which ensures empowerment, progress and innovation. So we can't curb directly, like there should not be any flow of data, but at the same time you've got to protect the privacy as well as to empower this with the innovation. All right, so this is the reasons. Another reason is given in the sense, like, to protect the autonomy, they have very so many provisions which we'll see later on. Autonomy in the sense like decision making with respect to how to use their data. All right, and to specify, so there is also specification under the act, like where and how it should be used. So those things should be known to the persons who is having the data, personal data on. All right. So that is next. We are speaking about the relationship of trust. Okay, what is trust between like persons who are collecting data? For instance, like any telephone companies or the UIDAI which collects the data from us. So as to have some sort of trust between us, person, and data fiduciary, in the sense those companies, agencies which are collecting the data, processing the data from us. All right. So in order to create such trust in the relationship. All right, and also it specifies the rights of individuals as well as to create a framework to implement with the technical measures, and also it has laid down some norms for cross-border transfers, because data now it's not just transferred within India, it is generated, transferred beyond the borders also. So how that can be done, because the recent case of Cambridge Analytica, you know about that, like how a company from UK, it has worked in US and all. All right, and lastly about this accountability, and it has provided the remedies if at all your data has been lost, what could be your way out for you, and about the establishment of data protection authority. So these are the basic reasons. So they have covered the entire aspects of it, right from accountability, transparency, the remedies, and the ways and means your data could be used. All right, so these are the salient features given in the data protection bill actually. So one is about the kinds of data, which is one is personal, sensitive, as well as sensitive personal related to children. Okay, so we'll see one by one what is exactly it is. All right, so whenever we speak about and we'll be seeing about data protection obligations and the grounds for processing data, the rights of personals data, and transparency and accountability features, and about the transfer of personal data outside India, and the exemptions, data protection authority, and also the offenses penalties. Okay, coming to the data classification, as we already know, there are normally three things. One is personal data, and second is sensitive personal data. All right, and third thing is the sensitive personal data related to children. All right, so normally this sensitive personal data is something related to your blood groups, the sex orientation you have, and your email passwords. Okay, so all those things will be classified under the what is called as a sensitive personal data. All right, which can't be easily accessed, which has to have, which carries a more importance than the personal data. Okay, here it is all other, apart from sensitive features, it is classified as a personal data. Your and that comes about children. The data of the children cannot be obtained without the consent. All right, even that is also very limited, considered as a sensitive. All right. Next, coming to the data protection obligations, as someone agency which collects the data, what are the obligations they have? So they have to make sure that the data process has to be fair and reasonable, and they got to, these are the limitations they have: the purpose limitation and collection limitation. For what purpose? If at all, see, we, whenever we install some applications, we don't know, like an app which is used for say reading books, that will ask questions about your not just your call letter ID, access to camera and all, but what is the need for that? Like an app which is related to book. Okay, so in such cases, they'll the agency collecting it. Okay, here the agency collecting our data or accessing our data, they have to show the purpose of which. So if it is like for, if it is collected for phone purposes, it has to be for that only limited. And the collection limitation also, it can be what sort of data is required, whether it is like iris or uh, related to fingerprints, whatever it is, that collection limitations over there. And about lawful processing, how it can be done that through a law. And about the notice, and what is the notice in the sense, like they got to, whenever they use it for something else, some other purposes also, you have the right to get that. Like they got to keep on giving notices, here it is used, here your data is used and all. Okay, and about the data quality in the sense, like if there is any misinformation or inadequate information, you have the these data agencies, they have the uh, obligation to complete that information. And about the storage limitation also, they can't store the data for a long time, maybe for 1 year or 2 year, but they got to tell them how long they're going to store, and after that, like how they going to give it back or delete it. All right, so then accountability provisions also they have been given. They have the obligation to be accountable to the persons who have given the data. Next is about the grounds for processing data. Like, okay, normally on what occasions data can be collected? For instance, okay, once, normally with the consent of the person, and sometimes when the state says or the court says. Okay, in these cases, whenever state says, in the sense like state by parliament, state by law made by parliament, they can give all the occasions wherein the state can demand the data. And about in case of prompt action, in the sense like in case of emergencies, especially medical emergencies, where your data related to medicines can be taken whenever that is. Okay, with respect to employment, in the sense like the employing, whenever you're employing any other job or a company, they'll have the data about your attendance, how long you have worked, or how much your salary, on all those things. Okay, here it is about reasonable purposes, that includes about CIBIL scoring, credit scoring things and all. Okay, all very generic purposes used in day-to-day purposes. Okay, on these grounds, our data can be processed by the agencies. All right, next, coming to the concept of like uh, what is about the rights. Actually, as far as the right is concerned, you as a person who is giving the data, you have the right to know where it is collected, how long it is collected, and then the rights as such, like about deletion also, like whether at what time it should be deleted, and you have the right to delete also if you don't want. It will be a continuing process. For instance, like you have given some data, you have given some access to data to some other agencies. Okay, if at all you, anytime you feel that your data is being misused or something like that, you have a legal remedy as well as to stop that data from use further. All right, so you have the right to ask any information related to your data. All right, and about transparency and accountability, the companies have to maintain the audit externally, internally as well. They have to store it properly with all those secure things. Okay, and as far as this transfer of personal data outside India, normally it is not covered, the data generated from outside. But if it is anything relevant to Indians or Indian business, okay, sometimes it can be transferred out of India, but with only with the permission, only with the law which has been enacted by the parliament. Okay, and coming to the exceptions, if you speak about the exemptions are like normally on what occasions this consent is not required. Maybe I said, like as I already said, like when there is a security issue of the state, when there is a legal proceeding, or whether there is a prosecuting agency which is demanding the data. All right, in case of research purposes, in case of journalistic purposes, there is an exemption given that you can collect the data, but again, that should not be misused for some other purposes. All right, and lastly, about the data protection authority, it has been like established. It will be established with a number like 6 full-time members with 1 chairman, and they'll be appointed by the union government on the recommendation of the selection committee, and that selection committee will consist of CJI, cabinet secretary, as well as one person who is an expert in the case and who has an expert and who has a professional experience in the case of data related data protection related things actually. Okay, so again they'll be given a term which has been given as a 65 years or 5 years, whichever it is lease, and so all those things are given, but that is not so much actually. But here the other things, like whatever the areas, the scope of data protection authority is majorly four. One is about the monitoring and enforcement of this provisions, and second is about the legal affairs policy and standard setting about like how much and how to give. So whenever they have given about the notification, they'll assist in that, and about the research and awareness, because everywhere we are speaking about big data, artificial intelligence, more about cyber security things, issues and all. So that will be incorporated with the help of it. And lastly, about the inquiries, about the adjudication. If there is any problem about the whoever it is breached the data provisions laid down here, they have the power to adjudicate also. This will know in future like how exactly it evolves. Okay, last about the penalties, we have both fine as well as imprisonment. Okay, so imprisonment includes almost 3 years if at all. Someone who breaches data, accordingly they'll be punished. Okay, there is again some terms about 4 to 5% of the turnovers and all those things and all not required. Okay, now so in future like you got to follow these things, because this is a draft bill. This has again a lot of again attention, and because again it may change based on the outcome of the other constitutional validity of the by the Supreme Court actually. Okay, so now let us see how far this is going to get a final shape. So now the stakeholders are come in and then start giving some opinions. So let us wait for maybe another few weeks, so how it is going to shape into a final bill, when it will be discussed by the cabinet, and then that will be tabled in the parliament. And even after that, like till the time it comes into act, there will be so much of changes, so many changes. So let us wait and watch for that. Until that time, you just, because this is a highly probable question, so please make a note of this. All right, so that's it for the day. If you have any clarifications, please write on the comments. All right, thank you.